Hi, I'm Jane Reardon at the Illinois Supreme Court Commission on Professionalism. Welcome to Reimagining Law. In this series, we explore how legal professionals are changing the delivery of legal services to better meet the needs of today's consumers. I'm joined today by Erika Harold of the Meyer Capel law firm in Champaign, Illinois. She's also a commissioner at the Commission on Professionalism. Welcome, Erika.
Thanks for having me, Jane.
So you're a litigator in a Champaign, Illinois law firm. What is the biggest way that you've seen the litigation practice be impacted by the pandemic?
The biggest impact has been that courthouses throughout the state have been shut down. And so the big challenge that's posed for clients is that hearings have been canceled, cases have been delayed, and trying to figure out how to navigate those new rules in the changing environment while trying to make some progress in your case has been an enormous challenge.
How have clients responded to the delays in cases and lack of access to the courthouse?
It depends on the kind of scenario and case that the client has. For some clients, they're incredibly understanding. They recognize the unprecedented nature of this pandemic. But for other clients, they have time-sensitive cases. And so one of the things that it's prompted is more clients are willing to consider settlement because they recognize they don't have easy access to the courts right now in non-emergency situations. And they've become more pragmatic, trying to decide what is most important to me in terms of resolving this dispute, and are there things that I'm more willing to compromise on in order to get the certainty that a resolution could bring.
So have you seen more settlements as a result?
I've personally seen more settlements where I've had some time-sensitive cases, some commercial disputes that involved litigants in Illinois and their opposing litigants were in other states. And so that introduced another layer of complexity. And so in trying to figure out what is going to be the best resolution here, the client said, we actually need a resolution within 30 to 45 days, and we don't have the ability to wait a couple months to find out when the courts might open. And so then we pared down our list of what's the most important thing that we need to get here. And the other side had that same sort of circumstances. And so they were much more willing to figure out how can we as attorneys get our clients into a situation where we can get the best win-win possible.
Interesting. And the Supreme Court in Illinois recently issued an order saying, as of June 1, the chief judge in each circuit should develop a plan for opening up the courts and conducting more hearings, either in person or remotely. How do you see that impacting your practice and the client's perspectives on litigation?
Well, obviously, we'll have to see what the rules look like. But what I hope is that cases that have been delayed, that they get priority in terms of scheduling, because there will be a lot of cases that are probably filed once the courthouses are open, but there will be a backlog that has occurred because of the closing throughout the state. So that I hope that the courts use their discretion to fashion rules that give priority to cases that have been stalled and give priority to cases where maybe just one hearing would actually enable the parties to make significant progress. Because some cases that are in the early stages of litigation, they're not in a place where you can start to issue discovery because you're not certain whether that will be necessary. So I hope that the courts and the judges really are judicious with the way in which they use their discretion and help us to move forward these cases.
You mentioned discovery. And discovery practices in litigation bring out a lot of practices, lawyer to lawyer, that have been criticized in the past. How have you noticed interactions between lawyers have changed during this time of emergency measures only in the courtroom?
I've seen an enhanced level of civility during this pandemic situation. It's sort of trite where people make fun of the fact that often our emails begin by saying, I hope you and yours are doing well during these challenging times. But the very act of writing that before you start talking about disputed issues actually helps you to put things into perspective. I also have noticed that people are willing to extend the benefit of the doubt. Oftentimes, if you don't get a call back immediately, Previously, people might assume that there was some sort of gamesmanship involved, but now we recognize that people are operating their law firms remotely in many cases. And so you recognize that people simply may not have received your message. And so in times where people might have gone to the court to say the other side is being obstructionist, people will reach out that second and third time and say, I understand that maybe you didn't receive my message. I wanted to reach out again. And you also have people really taking into consideration the many different challenges that people are juggling. It's not just the cases that people are handling. It's also the fact that some families may be impacted by COVID-19. People are trying to educate their children from home. And I think it's really brought an enhanced level of perspective and civility that I hope actually continues once the courthouses are reopened.
Do you think there will be some long-lasting changes in litigation going forward as a result of the pandemic?
I think there will be many long-lasting changes. I think that now that many people have been working remotely and that has worked successfully, I think you'll see many law firms give that opportunity to their lawyers now that they see that their lawyers have been able to manage their caseloads, and that will bring increased flexibility to lawyers. Hopefully, you'll see greater use of virtual hearings, and that will be a positive benefit, not just for lawyers, but also for litigants. To the extent to which you're able to reduce the number of times that lawyers have to go to court, you're bringing down expenses for clients. That actually increases the access to justice and access to courts that is so important right now for litigants. So I hope that having to essentially stop our processes gives us the ability, as we reopen them, to reimagine what it could look like. What would it look like if we were trying to design the most efficient ways of delivering justice to people? What would it look like if we were trying to allow lawyers to be able to most efficiently and cost effectively serve their clients? As awful as these circumstances have been, it really gives us a wonderful opportunity to reimagine the legal process.
Oh, what great hope. Thank you, Erika Harold, for joining me today. And folks, please like and share this video. Subscribe to our channel. You can get more updates about upcoming episodes in the notes below. Thank you so much for watching, and see you soon.